Riaan.
Hi Rebecca.
Welcome to IRiQ Talking IR. You're a solicitor in our team here at IRiQ Law, and you have a particular interest in workplace surveillance and covert recordings.
Yes.
But where would, let's say, employers start when it comes to understanding the legal position on making recordings or workplace surveillance?
Well, I think the first thing to bear in mind is that Australia doesn't have a single national workplace surveillance legislation. So the first question really is, in which state or jurisdiction do I operate in? If you operate in either the Australian Capital Territory or New South Wales, there is dedicated workplace surveillance legislation. But in all other states, it's a sort of patchwork of privacy legislation and sort of recording legislation, such as in Victoria. So really the first question is, in which state do I operate? If you do tend to operate across state lines and you happen to also operate in New South Wales or the ACT, it might be helpful to adopt what you're doing there or required to do in that state and then use that across your organisation.
Okay, so that's the high watermark for compliance, regardless of where you are. And what sort of obligations do employers have if they want to lawfully have a video surveillance operating in their workplace?
The legislation requires employers, if they want to conduct overt recordings or workplace surveillance rather, to give employees 14 days notice, and then to also include various pieces of information, such as, for how long will they be surveilled, what the nature of the surveillance is, is it audio, is it video, whether the surveillance will be ongoing or intermittent. So it really puts into that the employer put into writing to the employees, and it's very important that it is in writing, the nature of the surveillance. When that surveillance, the Act also sort of imposes different obligations when it's, for example, computer surveillance or when it's video surveillance, then there's additional obligations.
So are you talking about, for example, a clause in the contract or a policy or notices or all of those things?
It can be, and that generally is a good way to do it. But if let's say you're an established business and you're bringing in new pieces of surveillance, then it would just be notice to employees. It can be under the Act, it can be via email, but any way that you're able to demonstrate that employees did have the requisite notice is acceptable.
Okay, and you mentioned computer surveillance. There's some consternation out there in the media in particular about keystroke monitoring. So where would that fit into this?
So that would fall presumably under computer surveillance. The important thing with computer surveillance is it must be conducted within the dictates of an employer policy, and the employer must also be able to show that that policy is written in such a way that the employee was able to understand it. So, plain English is probably your best bet. Perhaps avoid overly lawyer speak. But yes, that would fall part of computer surveillance.
Okay.
And there have been cases where employees have been terminated due to non-activity picked up by keystroke activity.
Monitoring. And so I suppose that brings us to what happens if employers get it wrong. And I understand that there are penalties for non-compliance. Just talk us through how that operates.
So particularly with regards to the New South Wales Workplace Surveillance Act, any surveillance that's conducted not in accordance with the Act is considered to be covert surveillance, and there's only very limited situations where covert surveillance is authorised. Covert surveillance is typically only authorised where there's suspected unlawful activity, and then that covert surveillance is authorised by a magistrate.
Right. A bit like getting a warrant.
Exactly. But other than that, covert surveillance is where it's not authorised is actually an offence, and it can carry up to 50 penalty units. So it does represent for organisations quite a large, significant financial risk if contravened.
Okay. And look, there's probably some other risks that kind of shake out in those situations too, particularly, for example, if an employer says that they've become distressed as a result of the surveillance, whether it's reasonable management action, probably not if it's not compliant. So there's that sort of workplace injury type of risk. And then you've got the question of if you've picked up some kind of conduct that you want to action that might justify dismissal, you might not be able to rely on that as evidence because it's improperly obtained. So it sounds to me like there's a whole range of fronts on which an employer might have some risk.
And just to add to that, you know, like you mentioned, something that often is very much overlooked is staff morale and culture in the workplace. It's something that, because it doesn't have a tangible penalty, or because it's not a direct, there's no direct monetary consequence, it does get overlooked, but it is very important because culture is quite
central,
and essential.
Yeah, look, I agree, and I suppose it brings employers to a place where they really need to be clear about the why of the surveillance.
Exactly,
so that to the extent that they can preserve the trust that's important to that relationship. So covert recordings can sometimes undermine that trust and confidence. We see that more often when an employee makes a covert or secret recording. Tell us a bit about what happens in that space when it comes to audio recordings, whether it's lawful, and what some of the implications are in relation to those things.
So the Fair Work Commission has drawn a particularly clear line in the sand about employees making secret recordings. Essentially, they're seen as being directly opposite to an employee's duty of good faith and fidelity to an employer. And in and of itself, a secret recording can constitute misconduct, and serious enough misconduct to warrant summary dismissal.
And it's not difficult for individuals to make those recordings because we've all got the technology on our phones, which inevitably, you know, we have with us at work, depending on the environment. And I think sometimes individuals learn this the hard way when they try to rely on a recording in, say, the Fair Work Commission in a bullying or an unfair dismissal or something like that. And the Commission looks very unfavourably on that conduct and it tends to undermine their credibility.
Yeah, well, that reminds me, there's a decision in the Fair Work Commission, Altham Wooding and PKDK Adventures. Very interestingly, in this case, the employee was dismissed. She tried to challenge her dismissal, and as part of her evidence, she tried to submit a recording that she took secretly. Ultimately, the Commission didn't admit the recording into evidence, and it also held that that recording, the act of making that recording itself, constituted a valid reason for dismissal. So even though the employer dismissed her for a different reason, her making this recording was enough for the Commission to find that there was a valid reason and that her dismissal was ultimately not unfair, even though it only came out after she'd been dismissed.
After the event. It's a good example of the Commission taking notice of post-termination conduct or conduct post-termination. Which just goes to show that employees aren't immune on this front. And I think one of the other common misconceptions is that it's not unlawful to record a conversation that you're in, even though you haven't disclosed it. So a person who does that might be saying to themselves, and may justify their actions by saying, well, it's not against the law, which is true. But there are other consequences, like the ones you've just mentioned, which mean that it's not always a great decision.
And I mean, particularly from an employee's perspective, depending on the remedy that you're seeking, a secret recording can really hamstring you. So in some of the decisions where an employee has made a secret recording, even though and this is typically only where the employer's conduct is quite egregious, where the Commission does find, all right, there's unfair dismissal at play, and then the Commission is required to consider what the appropriate remedy is. As we know, the primary remedy is reinstatement, but the Commission has held that when an employee has made those secret recordings, that because that trust and relationship has been broken, reinstatement isn't an appropriate remedy. In another decision, an employee, again, unfair dismissal, Commission held that there was an unfair dismissal, but because of the recordings, the compensation that was ordered was diminished by up to 20% because of that act of making a secret
becomes
recording.
Effectively a penalty for poor conduct.
Exactly.
Yeah, that's right. Okay, so proceed with caution.
Yes.
Probably best if you're going to make a secret recording not to try to rely on
Exactly,
it.
yeah.
But it sort of then begs the question: well, what's the point
Yeah.
if you're not doing that? Okay, well, thanks. That's been really helpful. Okay, great. Thanks, Riaan.
Cool. Thank you. Thanks for having me.
Woo! We did it this time.